And iOS welcomes you all in this live session for subject Political Science. Subject code is 317 for senior secondary level. This is module number 3, Structure of Government. Lesson number 12, topic is Supreme Court of India. We already done part 1 and let's continue with part 2. Guardian of the Constitution. The Constitution of India is the supreme law of the land, and the Supreme Court is its interpreter and guardian. It does not allow the executive or the parliament to violate any provision of the Constitution. Can also review any action of the government which already allegedly violates any provision of the fundamental rights. This power of the Supreme Court is called judicial review. If it finds violation of any provision of the Constitution, it may declare the concerned law as ultra vires or null and void. It is on the basis of the power of judicial review of the Supreme Court that it is called guardian of the Constitution. It is also called a champion of liberties and a watchdog of democracy. Role and the functions of the Supreme Court. The Supreme Court has concurrent right with the high courts to issue directions, order and writs for enforcement of fundamental rights. These are in the nature of the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. These writs make the Supreme Court a protector and guarantor of fundamental rights. The idea is that in case of violation of a law or right, the court may issue direction for compliance with the Constitution. Thus, the citizens of India were secure as far as fundamental rights are concerned. right to declare a law passed by the legislature null and void, encroaches upon our fundamental rights. It has rejected many legislations which violated fundamental rights. This, show, this shows how the Supreme Court has always served as the guardian of fundamental rights. Writs. It is an order issued to a lower writs. It is an order issued to a lower court or a functionary of the state to take steps to restore rights of the people. Review of its own judgment. If the Supreme Court discovers that there are some new facts or evidences, or if it is satisfied that some mistake or error took place in its previous decision, it has the power to review the case and alter its previous decision. This is generally done when a review petition is filed, which we called PIL, is a form of review judgment. Normally, review is done by a bigger bench than the one that originally decided the case. Judicial review. It is a process through which judiciary examines whether a law enacted by a legislator or an action of the executive is in accordance with the Constitution or not. The power of the judicial review was first acquired by the Supreme Court of the United States. Now, it is freely exercised by the Supreme Court of India and in many other countries. and high courts also exercises this power. Judicial review does not mean that every law passed by the legislature is taken up by the Supreme Court for review. It only means that the court will review the law as and when it gets an opportunity. This is possible in two ways. First, the court can review the law if its validity is challenged. Next, the Supreme Court or High Court may get an opportunity to review a law in another situation also. If a person or institution feels that his or her rights are violated or a certain benefit due to him under a law is being denied, the court, while examining such a petition, may come to the conclusion that the law under which relief is sought is itself unconstitutional. Therefore, relief may not be granted. In a democratic country like India, the power of judicial review is an important guarantee of the right of the people. Besides, the Supreme Court has been interpreting various provisions of the Constitution. Its rulings are treated as law of the land. Supreme Court has a custodian of fundamental rights. Supreme Court play its role as a custodian of the civil liberties and in particular of the fundamental rights. The right to equality is an important right which ensures equality before law. The right to equality also means absence of special privileges and inequality of treatment. So, the Supreme Court, in the name of protective discrimination, has justified the benefits or concessions in the form of reservations or relaxation of eligibility conditions. Reservation of ST, SC in jobs or administration. Next, the right to freedom. The right to freedom has given various kinds of freedoms to all of us. For example, freedom of speech and expression or choose any religion. but the freedom of press was not mentioned in the Constitution. It was decided by the Supreme Court that freedom of press as a right is implied in right to freedom of expression. Thus, the court expanded the right to freedom.
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा और परीक्षा का अवसर एक बार ही क्यों मिलता फिर दुनिया में इसके केंद्र बात
कोई मन चाहा केंद्र चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा
Welcome back. Let's continue. The Supreme Court has regarded the right to know as an important right to be able to take part in the participatory process of development and democracy. Article 21. The court had ruled that the right to life in Article 21 implies and includes the right to education and clean environment also. Also, regarding the delay, in deciding the cases, the Supreme Court has held that delay in trial constitutes denial of justice. It has also laid down that speedy trial, releases on bail of under trials, free legal aid to the poor and accused are also the fundamental rights. Accused are also have the fundamental rights. The Supreme Court has used its power of judicial review and give various historic decisions to safeguard the right of the individual. It has stood guard of linguistic rights of minorities, religious rights of the people, welfare of the workers and daily wages earners. It has also taken action to protect bonded labor, prevent exploitation of women, children, and deprived section of society. The power of judicial review is an important guarantee of the rights of the people. It does not allow any violation of the Constitution. It has given several new interpretations to the constitutional provisions. Thus, it has protected as well as expanded the Constitution. Judicial review. Supreme Court, through its power of Judicial review has guarded our rights in various walks of life. The Supreme Court has given momentous decisions through what is called judicial activism. For example, Supreme Court take up case related to environmental concerns like closing of factories in Agra to protect Taj Mahal. The court has given such ruling as compulsory use of CNG fuel for the use of public transport vehicle in Delhi so that pollution could be brought under control. Similarly, for the protection of lives of people, it has made the use of helmets compulsory for two-wheelers users and even the pillion riders. Public interest litigation, which we call PIL. The judiciary, including Supreme Court, entertained litigation only from those parties that were affected directly or indirectly by it. For example, people of Delhi filed PIL for protection of environment, which brought up the case of CNG run vehicle. It heard and decided cases only under its original and appellated jurisdiction. But subsequently, the Supreme Court permitted case on the ground structure of government of public interest litigation. It means that even people who are not directly involved in the case may bring to the notice of the court matters of public interest. PIL. It is the privilege of the court to entertain the application for public interest litigation. The concept of PIL was introduced by Justice P.N. Bhagwati. PIL is important because justice is now easily available to the poor and the weaker section of society. The Supreme Court, on the basis of letters received from journalists, lawyers, and social workers, and even on the basis of newspaper reports, has taken up a number of matters of public interest. Under PIL, the right of under trials held under illegal detention have been restored. The Supreme Court ordered the release of many Denians without trial on the ground of their personal liberty, which could not be curbed due to judicial or bureaucratic inefficiency. The Supreme Court has also taken up steps to free bounded labor, tribal slum dwellers, women in rescue homes, children in juvenile homes, child labor, etc.
प्रकाशित करने राहों को आलोकित करने,
जीवन ये प्रकाशित करने राहों को आलोकित करने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने,
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने।
सीमा से विद्यालय जो मुक्त हो,
संसाधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो,
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने। परीक्षा का अवसर एक बार ही क्यों मिलता फिर
Welcome back. If any case of environmental pollution, the Supreme Court has ordered closure of a few factories near Kanpur, Delhi, and other places. With more and more decisions coming up from the Supreme Court, the scope of PIL has widened. Now, a person can approach the Supreme Court through a letter. And if the Supreme Court believes that the matter is of public interest, it can consider the letter to be a petition and direct the hearing of the matter so that public interest may be protected. The process of PIL has led to increased judicial activism. Exercise. Let's combine the questions from part 1 and part 2 and see. First, we will do fill in the blanks. The judge of the Supreme Court has appointed by the dash. What was the correct answer? Your option is President, Prime Minister, or Law Minister. The correct answer is by the President. The judge of Supreme Court are appointed by the President. Next question. The judge of Supreme Court retire at the age of dash. And your option is 60, 62 or 65. Correct answer is 65. Next question. The dispute between two or more states is brought before the Supreme Court under its dash jurisdiction. What is the correct answer? First, original, second, appellate, and third, advisory. Let's see the right answer. First point, original, is the right answer. Supreme Court under its original jurisdictions come brought. Next question. The Supreme Court is dash to give advice to the President of India. This is your options. Is first is bound and second is not bound. Option number 2 is right. The Supreme Court is not bound to give advice to the President of India. There is a two questions. First is, what is judicial review? What's its meaning? And question number 2 is, what does PIL means? You should do these two questions with your friends or by studying by yourself. Give the answer. So, this is the end of this chapter, part 1 and part 2. Hope you all understand. Thank you for watching me.